The Constitutional Court has denied direct access to the MK party and former President Jacob Zuma in their bid to challenge President Cyril Ramaphosa's decision to suspend Police Minister Senzo Mchunu and replace him with Firoz Cachalia in an acting capacity. Zuma and the MK party approached the top court to have the president's action declared unconstitutional. Let's get some context now. Newzroom Afrika's Ziyanda Ngcobo joining us in studio tonight. Ziyanda, good evening to you. So we're looking at two ministers of police.
Yeah.
Is that it?
Well, in essence, that's the nub of what the MK party and Zuma were trying to fight. The real question still remains here, Xoli, and we're yet to get some confirmation from the presidency, is that is Senzo Mchunu going to still be getting his perks as a minister, the cars, the salary, and the bodyguards, because that's at the heart of the issue of whether or not the president has powers to suspend. The argument was that the Constitution only talks about appointing or dismissing, but not a suspension. And the president's lawyers, you would have heard, talked about a precautionary suspension pending the outcomes of the commission. And so the MK party and their reaction is still going to be assessing and weighing up their options, but, you know, calling for people to take to the streets, in essence. Listen in.
Now, if you're going to refer to the issue of direct access to kick this matter out of this court, let us not forget that this is the same constitutional court that at first instance and last instance, when the case against President Zuma for him to be incarcerated without him having gone through and having had a day in court, this is the same constitutional court that allowed direct access for the incarceration of a man whom, by the way, had not even seen his day in court and sent him to jail. So it cannot be that for such a serious matter, such as what has been brought about the president's delinquency, on an issue that the South Africans themselves have brought up as an uproar, that this court now just sees it as an issue that should be sent back to the High Court. No. If you look at the issue of the CR17 statements, which today still have not been unsealed, it's the same court that is sitting with this issue. The issue of Phala Phala, he's never had his day in court. So the application of the law in this country, it's clear that Lady Justice has got eyes, and unfortunately, this is something that now the South Africans themselves and people on the ground must take into their own hands.
Interesting comments there. Lady Justice has eyes in South Africa. Let's conclude the conversation, Ziyanda, because another interesting comment from the MK party is that this now is up to South Africans. Does that mean that there is no longer appetite to pursue this in the courts now that the former president and his party are being sent back, perhaps, to the lower courts?
I mean, firstly, it's not that they're being sent back to the lower courts per se, but that's one of the options they could explore. I asked Dali Mpofu as well, who spoke in an unusual turn of events. Advocates don't usually speak, but he said, of course, because the matter is not in motion at the moment, he is able to speak, conveying the shock of his client, former President Jacob Zuma. But yes, either they can go back to the High Court, and in two ways, either to interdict the actual judicial commission of inquiry, because they say that this is not the correct recourse. A normal inquiry would have sufficed and not a judicial one because of the nature of Mkwanazi's allegations, or they could still be dealing with the challenge of having a Firoz Cachalia as acting police minister while there's a Senzo Mchunu. So we don't know what happens next. But Dali Mpofu, on the actual judgment that was handed down, seeming a bit upset at the fact that it only dealt with the issues of direct access, where they said he's failed, and the MK party's lawyer, Anton Katz, failed to make an argument for both direct access and exclusive jurisdiction. This is what he had to say.
Whenever there's a difference between exclusive jurisdiction and direct access. Exclusive jurisdiction is when only this court has jurisdiction. But direct access is when other courts have jurisdiction, but there are, in the interest of justice, compelling circumstances for you to come here. I think the public must understand the difference between those two things. So the only question, put aside the question of exclusive jurisdiction. On direct access, the only question is whether anyone in this country thinks that these issues that were raised by Lieutenant General Mkwanazi, which have affected all South Africans, are of sufficient significance for them to have warranted direct access compared to all these other issues. Gandla, secret ballot, all the cases that were given direct access. And that would be our approach from a legal point of view. Yeah. We can't comment on the issues that Mr. Ndlela is raising, which are in the political space.
All right, Ziyanda Ngcobo, so the essence there is that Dalimpofu is still going to go now and consult the client, and only thereafter will we know their next course of action.
That's right, Xoli. And of course, the other option could be a rescission judgment. Remember in 2021, that was the first time it was used in South Africa's history when they tried to overturn the ConCourts, going back to the Constitutional Court, which had ruled that former President Jacob Zuma must be arrested. They went back to the court to try and have that decision overturned. The point is the merits of the case. We don't know what the Constitutional Court would have thought because they've denied direct access. So that has not necessarily been dealt with. All they were saying is that, well, you've come to the wrong place and it's not an issue that is within our purview.
Ziyanda Ngcobo, thank you very much indeed.